Hello guys, welcome back to my channel Rahul Friend Study. In this video, we just try to cover the nature, definition, and meaning, a scope of law of torts by a leading case, namely White versus John Warrick and Company Limited. Citation of this case is 1953, second edition, page number 1021 of A11ER. So guys, before move ahead, please subscribe this channel and press the bell icon to get notification on time. And you can also get this PDF from my Telegram channel or group, namely same as YouTube channel Rahul Print Study. In this previous video, I just covered the syllabus from the case mates provided by Delhi University to Faculty of Law. You can check the syllabus, whole syllabus of law of chart for the first semester. So in this video, I just try to cover the next part uh, uh, of the first unit of syllabus law of chart. So guys, let's start. So guys, please open your casemates of law of charts. Page number. You can see the page number 1. Or in PDF, just open page number 8. Okay. Introduction, definition, nature, and scope of law of charts. The author of this case or judge, namely L. Singleton, Justice L. Singleton. Okay, on the behalf, the judgment has been written. So, the plaintiff, a news agent, tobacconist carrying on business at Conobari, entered into an agreement with the defendant that they should supply him with a tradesman's tricycle, a tricycle with a large carrier in front for use in the delivery of newspaper. The arrangement was embraced in a written contract dated April 13, 1948. The contract was a printed form used by the defendants on which their name appear in print, and the agreement is stated on the made between them, described as the owners, and the plaintiff, who is described as the hirer. By skill 1, the owners agree. By CL 1, the owners agree to let, and the hirer agrees to hire. Carrier cycles notes 13404 409 for the term of 3 years for the date of thereof, hereof, and thereafter from the year to year, at the weekly rent of 5 pesos each, payable quarterly in advance at the owner above address, the first payment being due on delivery of the machines. By sale 2, in the consideration of such sum, the owners agree to maintain the machines in the working order and the condition, punchers accepted, and the supply spare carriage as soon as possible when the hirer and machine are being repaired without any charge beyond the agreed amount as above. The owners also agree to supply lamps and accessories and the like, and to repair damages in certain cases. On the owner supplied a machine which was used by the plaintiff for the considerable period, and which, so far as we know, was kept in order until towards the end of May 1950, when the machine which was in plaintiff's possession under the contract, was in need of repair, and owners were so informed. On Saturday, June 3, A representative of the owner went to plaintiff's shop and left a spare tricycle instead of that which was out of order, which he took away. In so doing, the owner were purporting to perform their obligation under the schedule of the contract. The plaintiff did not examine the tricycle but very soon mounted it to go about his work. When he had gone about a quarter of a mile, the saddle went forward in such a manner that he was thrown off the tricycle on the ground and was injured. He said he got up, pushed the tricycle back to his shop, the saddle then sloping down to the crossbar, and when he examined the tricycle, he found that the saddle was loose. He was not thought at first to be badly hurt, but unfortunately, he had suffered an injury to his knee. He was in hospital for some considerable time, suffering from synovitis. Parker J., who heard the plaintiff's claim, said that if he had found the plaintiff entitled to damages, he would have awarded £505. That was a provisional assessment and no more. The evidence given by the plaintiff and by his wife and by a young man named Anthony, implied by the plaintiff, seemed to show that the tricycle was out of order in that some nuts under the seat were rusty and could not be moved. Anthony, the thief witness, whose evidence impressed the judge on the point, was not implied by the plaintiff at the time of the trial, but was engaged on the delivering newspaper and like for the plaintiff in June 1950. He told the judge that after hearing of the accident, he saw the tricycle and the saddle had been titled back. He said that on several occasions thereafter he used the tricycle and the saddle used to slip backwards and cause him to lose control. He tried to tighten the nut, but it was too rusty to move. There was other evidence on that on both sides. The plaintiff set up two causes of the action against the owners. The first was that owners were responsible to him in damages for breach of warranty. He was said that they were under a duty under the contract to supply a tricycle which was reasonably fit for the purpose for which it was required. That they did not do so. The plaintiff was entitled to damages. The second claim of the plaintiff was, if the person from whom I had this cycle owed a duty to care reasonable care, that is to care that care which a reasonably careful tricycle owner would take on the hiring to another of the tricycle for his use, and if held in that duty, if you had examined the tricycle, you would have found that the nuts were rusty and that the saddle was loose. I used the tricycle in the way in which it was intended that I should use it, and I sustained an accident because you had not fulfilled your duty. You had not taken reasonable care, you were negligent, and I am entitled to damages. I replied to both those claims, and the owner denied negligence, breach of duty, and breach of contract. They added a plea in para 4 of the evidence of the defense. By clause 11 of the written agreement between the parties, the owner are not liable for the any personal injury to the plaintiff when riding a machine provided for him. Clause 11 of the agreement is nothing in the agreement that rendered the owner liable for any personal injuries to the riders of the machines hired, nor for any third party claims, nor loss of any goods belonging to the hirer in the machines. It is considered by counsel for the plaintiff that that clause would prevent the plaintiff from succeeding on a claim based on breach of contract. But his submission is that in the in that circumstances proved there was negligence on the part of the defendants, and that the clause is no bar to an action for damages for the negligence. The plaintiff submitted that of clause 11 relieve, relieves the owner in respect of a claim for breach of contract arising from the agreement. It does not absolve them if there is a clause of action established on the ground of negligence. Counsel for owner submits that if there was negligence, it was negligence in connection with the performance of the contract, that the machine which was supplied in performance of the obligation arising under the contract, and that what was done under the agreement. He contended that the clause of action, if there was one, arose out of the agreement, and that whether there was negligence or not, clause 11 prevents the plaintiff from succeeding in an action of this nature. That gives a rise to a question of some nicety. I am inclined to think, for the purpose to a speech of Lord Macmillan in M. Alistair or Donegal versus Stevenson. On the one hand, there is a well established principle that no one other than a party to a contract can complain of breach of trust, breach of that contract. On the other hand, there is a equally well established doctrine that negligence apart from contract gives a right of action to the party injured by the negligence, and here I use the term negligence of the course in its technical legal sense, implying a duty owed and neglected. The fact that there is a contractual relationship between the parties which may give rise to an action for breach of contract does not exclude the coexistence of right of action founded on negligence as between the same party. Independently of the contract, stuff arising out of relationship of this, the best illustration is that the right of the injured railway passenger to sue the railway company either for the breach of contract for safe carriage or for the negligence in the carrying aim, and there is no reason why the same set of facts should not give one person a right of action in contract and another person a right of action in tort. I may be permitted to adopt as my own the language of a very distinguished English writer on this subject. I appear, says Sir Frederick Block, Law of Torts, 30th edition, page number 570, that there has been, tough perhaps there is no longer, a certain tendency to hold that facts which constitute a contract cannot have any other legal effect. It is clear from those words of Lord Macmillan that an action for damages for breach of breach of contract, and an action for a tort may arise from the same set of facts. It is said that position arises in this case, and that of an action for damage for breach of trust, breach of contract, may be said to be barred by clause 11 of the contract. It cannot be said that the word of that clause shut out the hirer from what he would normally have. An action for damages for the tort of negligence. In Taylor versus Manchester, Sheffield and Lincolnshire RY Company, Justice Smith said, it is clear that a person lawfully upon railway premises may maintain an action against a railway company for injuries sustained whilst there by reason of the active negligence of company's servants, whether he has a contract with the company or not. In the circumstances of the present case, the primary object of the clause, one would think, is to relieve the owners from liability for breach of contract or for breach of warranty, unless then there be clear words which would also exempt from liability for negligence. The clause ought not be construed as giving absolute exemption to the owner if negligence is proved against them. The result is that clause 11 ought not, I think, to be read as absolving the owners from liability for negligence if it is proved that the injury which the plaintiff sustained was due to lack of that care which one in the owner's position ought to take when supplying a tricycle for the use of hirer. If that is proved, then the owners do not escape liability by reason of clause 11. Justice L. Denning, in this case, the owner supplied a tricycle on hire to plaintiff, who was a news vendor, intending that he and his servants should ride it. The tricycle was defective, and in the consequences of the defect, the plaintiff was thrown off and injured. He now claims damages for breach of contract or negligence. The owner claims to be protected by the printed clause which my lords has read. In this type of case, two principles are well settled. The first is that if a person desires to exempt himself from a liability which the common law imposes on him, he can only do so by a contract freely and deliberately entered into by the injured party, in words that are clear beyond the possibility of misunderstanding. The second is that if there are two possible heads of liability on the defendant, one for negligence and the other a strict liability, an exemption clause will be construed so far as possible as exempting the defendant only from his strict liability and not as relieving him from his liability for negligence. In the present case, there are two possible heads of liability on the owner, one for the negligence and the other for breach of contract. The liability of the breach of contract is more strict than the liability for the negligence. The owner may be liable in the contract for supplying a defective machine, even though they were not negligent. In these circumstances, the exemption clause must, I think, be construed as exempting the owner only from their liability in the contract. The note from their liability for negligence. Counsel for the owner admitted that if the negligence was a completely independent tort, the exemption clause would not have held. But he said that the negligence here alleged was a breach of contract, not an independent tort. The facts which give a rise to the tort are, he said, the same as those who give rise to the breach of contract, and the plaintiff should not be allowed to recover merely by the following his action in tort instead of contract. In my opinion, the claim for negligence in this case is founded on tort and not on a contract. That can be seen by the considering what would be the position if instead of the plaintiff himself it was his servant who had been riding the tricycle and had been injured. If the servant could show that the owner had negligently sent out a defective machine for immediate use, he would have had clause of action in negligence on the principle stated in M. Alistair or Dongho versus Stevenson, and as against the servant an exception clause would be not defense. That shows that the owners owed a duty of care to the servant. The owner owed a duty of care to the servant, a fortiori, a fortiori, a fortiori they owed a like duty to hirer himself. In either case, a breach of that duty is a tort which can be established without relying on any contract at all. It is true that hirer could also rely on a contract if he had wished, but he is not bound to do so. If he can avoid the exemption clause by framing his claiming in tort, he is, in my judgment, entitled to do so. So guys, in this video we just cover a case of White versus a company, John Warrick and Company Limited, for understanding a case related to the plaintiff and defendant. Of course, there is two person, and one is plaintiff and another is defendant. Defendant would be a company or a person, etc. So by this case we just learn about the fact of the duty of care negligent regarding the tort or contract. So that's it for now guys. In the next video I will cover a next case, leading case for namely a town area committee versus Prabhu Dayal in the context of law of tort, nature, scope and definition. So you can also go through the some definition of tort and of Salmond, Shamond, Winfield or Pollock. In that definition you could find the characteristics of tort and constituent element of tort. So that's it for now. I hope this video will help you to understand the meaning and definition and nature of tort. Thank you so much for being here. Have a nice day.